Many of us seek to balance our professional lives with our personal values and beliefs. Sometimes, this means our faith traditions guide our daily routines, including when we can work. Have you ever wondered how your workplace supports your religious practices? Employers are generally required by federal law to provide reasonable religious accommodations for work schedules, unless doing so would cause an undue hardship on the business. This means your employer should work with you to adjust your schedule to observe religious holidays, attend services, or meet other faith-based obligations. This requirement stems from Title VII of the Civil Rights Act of 1964, which prohibits employment discrimination based on religion. The law mandates that employers make reasonable adjustments to the work environment or practices to enable employees to practice their religion. However, there's a limit. Employers are not required to provide an accommodation if it imposes an undue hardship. The Supreme Court has clarified this to mean anything more than a de minimis or minimal cost or burden on the employer's operations. This is a lower standard than for disability accommodations, which requiring a significant difficulty or expense. Factors like the nature of the employer's business, the cost of the accommodation, and the number of employees available to perform the work are all considered. To receive an accommodation, the process usually starts with an employee making a clear request to their supervisor or human resources department. It is helpful to explain the religious belief or practice that conflicts with the work schedule. Once requested, both the employee and employer should engage in what is called an interactive process. This is a good faith discussion to identify potential accommodations that would resolve the conflict. Examples might include flexible arrival or departure times, staggered work hours, voluntary shift swaps, or reassignment to a different position. Understanding the de minimis cost standard is key. It means that while employers must try to accommodate, they are not obligated to incur significant expenses or disrupt essential business operations. For instance, repeatedly paying premium overtime rates to cover a religious absence or allowing an absence that jeopardizes public safety would likely constitute an undue hardship. However, simple shift swaps or minor schedule adjustments that do not cost much or disrupt operations generally fall within reasonable accommodation. The interactive process is crucial for finding creative solutions that respect both religious freedom and business needs. Ultimately, these provisions empower employees to uphold their religious observances without jeopardizing their livelihoods, fostering a more inclusive and respectful workplace culture. By understanding your rights and engaging proactively, you can find practical solutions that enable you to honor both your faith and your professional commitments.